Sahaj Vidhi www.sahajvidhi.in. Question 1. International law and municipal law are two branches of unified knowledge of law, which are applicable to human community in some way or the other. Elaborate with the help of prevalent theories. Model answer. International law and municipal law, or domestic law, represent two distinct interconnected legal systems that govern human communities. International law primarily regulates the conduct of states and international organizations, as well as, to a growing extent, individuals, in their relations with each other. Municipal law, on the other hand, is the internal law of a sovereign state, governing the relations between individuals within that state and between individuals and the state. The relationship between these two systems is a subject of ongoing debate, with two prevalent theories offering different perspectives. 1. Monism. This theory posits that international law and municipal law form a single, unified legal system. In a monist system, international law is considered supreme and directly applicable within the domestic legal order without the need for transformation or incorporation by national legislation. If there is a conflict between international and municipal law, international law prevails. Proponents of monism often emphasize the universal nature of law and the idea that all law ultimately derives from a single source, often rooted in natural law or a common legal consciousness. States adopting a monist approach typically view international treaties as self-executing, meaning they become of domestic law upon ratification. 2. Dualism. This theory asserts that international law and municipal law are two entirely separate and distinct legal systems, operating in different spheres and regulating different subjects. International law governs relations between states, while municipal law governs relations within a state. For international law to have any effect within the domestic legal system, it must be explicitly transformed or incorporated into municipal law through specific legislative acts. Without such an act, international law remains external to the domestic legal order. In case of a conflict, a dualist state's domestic courts would apply municipal law unless the international norm has been specifically incorporated. Dualism emphasizes state sovereignty and the idea that a state's internal legal order is supreme within its own territory. In practice, most states adopt a nuanced approach that incorporates elements of both monism and dualism. For instance, a state might treat customary international law as directly applicable, monist approach, but require treaties to be enacted into domestic legislation, dualist approach. The specific relationship often depends on the constitutional framework of each state and the nature of the international norm in question, regardless of yet part. The theoretical framework. The increasing interconnectedness of the world means that international law increasingly influences and shapes municipal law, particularly in areas like human rights, environmental protection, and international trade, making their interaction a critical aspect of contemporary legal studies. Please visit our website www.sahajvidhi.in for more content.